We'll be starting this meeting. There had been a little tech issue. So, good morning, everyone. It is my pleasure to warmly welcome you all to the today's workshop of intellectual property rights, IPR, patent, and design filing. This workshop is being organized by NIT Business School, Greater Noida, in association with the Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, under the National Intellectual Awareness Mission, Government of India. In today's rapidly evolving and innovation-driven world, protecting ideas and inventions have become as important as creating them. Intellectual property rights play a vital role in encouraging innovation, safeguarding creativity, and promoting technological advancement. This workshop aims to provide a valuable insight into the fundamental of IPR, the process of patent filing, and the importance of design protection for innovators, researchers, students, and professionals. Before we begin the session, I would like to take a moment to acknowledge the visionary leadership of our institution. Dr. Arun Kumar Singh, Director of NIT Business School, Greater Noida, is an alumnus of IIM Lucknow with over 20 years of experience in academia and industry. He brings a unique blend of academic insights and industry expertise to his leadership. Dr. Singh serves as the Regional Director of the International Association of Commerce and Management and is also an honorary member of National Executive Council of the Due Process of Law India Foundation. He holds certification from prestigious institutions including EDII Ahmedabad and IIM Bangalore. Additionally, he is certified marketing professional and a Microsoft certified educator with specialized training in emerging domains such as blockchain, social media, and advanced analytics. A prolific academic contributor, Dr. Singh has published over 25 research papers, authored 5 books, and holds 5 patents to his credit. He is also associated with the editorial board of International Journal of Economic Review and Business Research and is a lifetime member of several professional bodies, including ISTD, ISTE, and ICA. His consulting experience includes reputed organizations such as SCL Parrot, Nestle India, GMR Infra, and the Times of India. And his key research interests focus on consumer buying behavior and retail. I now request Director NIT Business School, Greater Noida, to kindly deliver the welcome address. Sir, please.
Very good morning to everyone. I believe I'm visible to everyone as well as audible to everyone.
Yes, sir.
Yeah. So once again, a very good morning and a very warm welcome to the guest of the day, Mr. Kumar, the head PGP, the deputy head, all the faculty members, especially Dr. Pooja and Dr. Ahmed, all the members who are coordinating for this event, and all the participants, dear students. To begin with, I would especially mention Dr. Morukar. We started the initiative with him, and where he, at the very first stance accepted it, and today we are doing this workshop, which is very important, and the kind of time we are going through makes the relevance more, contemporary in terms of. Once again, Mr. Raju, a warm welcome on behalf of NIT Business School. At our institution, we have been doing this, these kind of initiatives of late in various domains where we are encouraging not only the student but faculty to come and probably innovate the ideas, and if possibly we can go for the patents which are actually working. Now, since this is more of a workshop, we are in hands-on. We are going to get to know what are the modalities and how we should look into it. Now, there are certain points which I would like to emphasize because this is an important initiative which this institution has taken in collaboration with the Rajiv Gandhi, National Institute of Intellectual Property Management. Now, this awareness has to come among all of us that, in terms of numbers, we are growing like anything in the country, but yes, the quality and the pain areas needs to be worked on too. Right now, we are in 21st century and we're talking about knowledge economy. And I think the intellectual property happens to be the infrastructure of the knowledge economy, and we all are responsible to protect it and to prove our mettle on the international forum. Of late, we have seen the kind of nuances, what these intellectual properties can do and the kind of challenges they can pose. If you remember, a company like Alphabet, which is, what happened with them when they wanted to start a domain with Alphabet and they were struggling to do that. So that means the kind of importance intellectual property has to be given still is missing in our space. Another part is the quality, which I earlier said. So with that, I think this workshop will facilitate and give us the nuances, what are the intricacies of those, and particularly those students or the first time who are going to venture into this terrain, and those who are already into it, probably they'll take the benefit from the expertise of Mr. Kumar. And I'll encourage our students, particularly from our institution also, that take maximum Q out of these, sessions and try to come up with your ideas with the help of faculty or your mentors from industry and file certain patents which are actually going to help the country as a whole and in fact society as a whole. So with that, once again, a warm welcome to Mr. Kumar and a special mention to Dr. Pooja and Dr. Ahmed for coordinating and doing this workshop today. Uh, Over to the speaker. Sorry, the moderator.
Thank you very much, sir, for your insightful words. Now, proceeding further, now it's my privilege to introduce our esteemed resource person for today's workshop, Shri Kumar Raju. Shri Kumar Raju has been working for more than 13 years in the central government under the Patents Office, Ministry of Commerce and Industry. He is currently serving as the Assistant Controller of Patents and Design at RGNIIPM Nagpur. He is also an active program speaker at RGNIIPM Nagpur, which is the only central government national IPR training institute in India. With vast experience in the field of intellectual property, he has delivered more than 300 lectures on various platforms across the country, spreading awareness about the patents, designs, and IPR. Academically, Shri Kumar Raju holds a master's in technology in industrial engineering from prestigious IIT Delhi and a Bachelor's of Engineering from GB Pant Engineering College, Garhwal, Uttarakhand. During his tenure at the Patent Office, he has examined and disposed of thousands of patent applications and has delivered numerous lectures on IPR across different parts of the country. He has also given decisions on several patent opposition cases filed by the reputed domestic as well as international industries. In recognition of his expertise, he was deputed by the Government of India for a specialized training at the Japan Patent Office in Japan, where he received advanced training on patent examination and IPR related issues. We are truly honored to have such an experienced and distinguished expert with us today to share his knowledge and insights. With this, I once again welcome all the participants and request everyone to actively engage in the session and make the most of his valuable learning opportunity. Uh, our resource person, Shri Kumar Raju, now I request you to kindly deliver this expert session on for this workshop. Thank you, sir. The stage is all yours.
Uh, thank you, sir. Thank you, director, sir. And I welcome all the participants on the behalf of Rajiv Gandhi National Institute of Intellectual Property Management for delivering a session on intellectual property rights. And I also appreciate your efforts to have a collaboration with RG and IPM for having your IP friends or your IP family at your institute. So it is going to helpful in all the manners. So before starting this session, I want to share my PPT so that all the participants have a glimpse on it. And after so is my PPT is visible? Should we start?
Yes, sir, it is visible. You may start.
ये क्या रहा 23 तारीख आज है क्या आज 13 तारीख है ना हाँ sorry for the interruption. So let's start the today's topic. It's intellectual property. Now You know that we have the very well versant information about the intellectual and very versant information about the property. Now the time has come to combine these two property, intellectual plus property, and it's completely product of our human mind. Our mind is our laboratory. Any new information, any new thing which starts from our mind, you know that if I say that what is the thing that is most unused in today's scenario is the creativity and idea. So many ideas comes in the minds of the youth at every stage of the people, but due to lack of awareness it goes in vain. So the point of this scenario that any creativity, any idea, any technology, it should not go in a waste. It has to be protected in any manner. So that is the main purpose of this intellectual property workshop. So now what is intellectual property? What can be understand by the first time if somebody is hearing this session? So they will feel that any creativity, it has to be protected in their name. Either it's a technology, design or industry, anything, it has to be protected in their name. Any trademark, copyright. So that is the main purpose, and they want that if somebody wants to use your creativity, they have to take the permission from yourself. Now this is a smart shoe which has been developed by an Australian company. So the point is that uh, why this idea only came to this company? Why this idea didn't came to the shoe making companies in our country? So there might be a lack of awareness that we have to be more and more creative. So in February 1974, few engineers from Taiwan, they were just sitting together and were discussing on the breakfast. And on that breakfast, they have decided to overcome with the problem with the other countries in terms of the technology. And they decided to go with the semiconductors. And you know that that country is the leading country in the field of the semiconductors. So that's why sitting together, putting an idea together is the main purpose of this IPR. And the second purpose, whatever is the most important purpose, that is the welfare of the society. So many before the independence in there are so many samaj sudharak, there were so many persons are there now are nowadays also there. Now the time has completely changed. Now the for the welfare of the society, you have to contribute through the IPR. Even your small technology, it doesn't matter whatever the small technology, purpose is that the utility, usefulness, how much it is useful to the society. So it will automatically combine for your intellectual property right, increase your wealth in that terms. So this is a professor from Nagpur. He has invented a formula for making herbal cold drink using the mahua flower. Okay, and he got the patent for that. And when he will need the mass production, he can go for the commercialization also. And these are the certain few people from the from a very basic background, you can imagine that, and they have also filed certain technology in their name and with their utility, so they also got the patent in their names. Now, if we say about the background of the intellectual property, property can be tangible and intangible. Now we are here to discuss about the intangible property. So intangible property, it's an intellectual property. It has an industrial property and copyright. And industrial property is further divided as patent, copyright, trademark, industrial design, geographical indication, layout design of the IC circuit, and protection of trade secret. We will discuss all this topic one by one. Now, intellectual property means what? It's an intangible creation. It involves human intellect, and it must have certain commercial value. Nowadays, you have heard that so many person are taking the patents. But if I ask about, if somebody will ask it, what is the commercial aspect is they are getting? So you will get hardly any answer that that it is going to be commercialized. So if it is not going to do, then in that case the purpose is not going to solve, and it should be used like an asset, like any other forms of property. So on the basis of IP, you are able to get the following right: exclusive right, territorial right, and licensable right. If I say about the exclusive right, so you have the right for the manufacturing, production, selling, using, exporting. All these types of right will be live with the first applicant only. So all the applicants which has been filed as the name of the patentee, they have the only rights. In that manner, it's a negative right. Nobody can use their right without their permission. And it's also a territorial right. Suppose that you have filed your invention in India and you want that outside India somebody is infringing your technology, or you want that if there is a business potential outside the India, you have to file your invention outside India also. Since patent IPR is a law and law is territorial in nature, so you have to file your application in that country as per the law of that country. And although there is certain PCT, patent corporation treaty is also there, and Paris Convention treaty is also there, you can also take the help of these two treaties to file your invention outside the India, and it's also a licensable right. So you can earn royalty and enhance your economical way through the licensing. Now, if we say about what is patent, so patent is an exclusive right granted by the central government to the patentee, and terms of protection is 20 years from the date of filing or priority, and it is for the 100% for the commercial gain. So, and in consideration of that, you have to fully disclose your invention. Suppose that whatever the invention you have invented, so it has to be documented. So it has to be present in the paper form. Okay, we do not require any model and prototype. It has to be documented and it has to be disclosed in a fully disclosure manner. And patent is being provided for the invention. And what does invention means? Invention means any new product or process which has the utility, novelty, non-obviousness, and it's not known to the public before the filing date. Now if I will ask, out of all these 5 points, which point is the most important point for commercialization of your invention? So the answer is the utility, usefulness. Suppose that electricity is a very good invention, but if a common people or ordinary common people cannot be able to use that invention, then there is no meaning of that invention. So what is the purpose of patenting anything? Means whatever your technology, it has to be used by a very simple person. Not too much educational qualification is required for using that invention. So in that manner, you have to modify your invention so it become usefulness, and that is the main criteria through which it can be go for the commercialization also. Now the 2 points are there. What is the role of the inventor? Inventor role is to invent anything. Now the second part is the role of the drafting, how you are drafting your invention. So at your academic level, you can teach your student how to draft the invention, how to write the complete specification. So let's see with an example. This is a sapner which got patent in 1822. Now how they have drafted the claims. They have taken the protection for all types of tool which has this technical feature. What is the technical feature? A pencil's writing point by saving away its worn surfaces. So they have claimed all types of tool which will perform this technology. I want the protection for that. So in that case, I can say that patent is just like a football game in which you have to make offense and defense simultaneously. Offense means you can capture as much area you want by broadening your scope of your invention, and you have to defense also when you will somebody will say that no, this is not your invention, please narrow your scope. So you have to defend also. So in that case also, so the point is that drafting is just a time consuming thing, but it doesn't require any resources. But for any, if you are going to make any product or process, it requires certain resources. So you can see these through. Now this is the Thomas Alva Edison who has invented the bulb in 1878, and now the main point is that with what was the invention of the Thomas Alva Edison? So the part of the filament, when you switch off the bulb switch, so after putting 70-80 times, that filament should not be broken. That was the main invention of the Thomas Alva Edison. So do you understand that with only this information, can this bulb be manufactured? The answer is no. There was inert gas. There is a glass covering also. There is other elements are also attached. So for that, different inventors have filed the invention for that. So what the key point is there? Key point is there. One application for patent is being filed for a single inventive concept. When you have to file for the multiple inventive concept, you have to file separate files. So there is a very less chance that somebody can read your document and make the bulb, because they have to combine 4 or 5 inventions together, and after that they can be able to make able to make that invention. And this is the Bluetooth device which has been invented in 1994 by the Jap Heston. These are the famous Indian inventions: nano cars, hepatitis vaccines, Apple prosthetic leg, and they have also earned millions and millions of dollars by making these inventions. And these are the purpose of this slide is again use utility. You have to make you more and more user friendly. Your invention has more and more user friendly, so that it can be have the utility or the more and more commercial aspect. Now there are certain common mistakes done by the inventor, that they usually publish their paper and after that they come to the patent office and say that we need the protection for my invention. In that case, patent office says that since it is already published, so we will not provide you any protection. So for getting protection, it has to be protected within 12 months of the time. Okay, so there is a grace period of the 12 months. So after publication, within 12 months, you can file your invention in our office, and you can get the benefit of the grace period. Okay, now the basic point comes from here, that what is the role of the universities? What are the missions? So the role of the university or mission, if I say that first mission is to educate the human resources, that is common to all, everybody knows it. Now what is the second role? Second role is to create the research paper in any field, either in business, arts, commerce, technology. In any fields, you have to create the research paper. Now the third part is to what how much that your research paper is used by and resulted by the common people, by the society, by any industry or any small scale industry, any startup. So if your application research work has the applicability or the result oriented for the society or for the industry, so in that case, IPR plays a very important role. So we have to understand that where the university lies, what are the leading parameters, what are the lagging parameters. So on this, you can also become a leading protector of the IPR. Now, it is also possible that all person cannot be a scientist. So there are certain other career opportunities also associated with that. You can become a patent agent. If you are a science graduate, you can become a patent drafting specialist, and for drafting claims, specification, become trademark and copyright agent. If you are a law graduate, patent valuers. So IP management, IP strategy development, brand management, IP portfolio management, organization and IP investment controlling, master's program in IP management, patent analyst, licensing specialist, patent LPOs, and you can also join the government offices if you are an engineering graduate or science graduate as the post of examiner of patents and design. And you can also provide your services at different IPR policies and IPR cell. So the role of the IPR cell will be to have an interview with the creator, any type, whether it is patents, design, anything, it has to have an interview. And for the patent, you have to ask that whether there is novelty or inventive step or not. So if it is there, you can convince them to go for the filing. And simultaneously, the role of the IPR cell should also be there to go for the market research, that is their technology is useful for the market or not. Now come to the design. So suppose that you are manufacturing any mobile, and the cost of manufacturing of that mobile is 100 rupees. Now out of that 100 rupees, you are putting 5 or 10% extra for making new design of that mobile. And since you know that any customers, they got just fascinated on the basis of the aesthetic feature of that an article, and it derives from its visual appearance. So design, if I say that it just focused on the visual appearance or the aesthetic feature of an article, so that's why it is providing more and more design features, and it has the potential of 70 to 80% of the selling point. So what is the definition of the design? On the basis of that, you can get the design registration. So design means only the features of the shape, configuration, pattern, ornament, composition of lines or colors, and it is applied to any article. And so it may be 2D or 3D or in both forms. So any software design is not applicable. So design is being provided for the article. So patent is being provided for the invention, and design is being provided for any article, and it has certain industrial process or means, and industrially process. So and it has to be a finished article. Semi-finished, unfinished article is again not applicable for the design registration. And design is being provided protected for the 10 years, and you can extend it for the next 5 years. So total protection is for the 15 years. So now, if we say certain applications of the, let us see the certain application. So this is the cup set. You have hardly seen in your household, but you will go to the 5-star hotel, 3-star hotel, or certain more cafes are there. So you will get see numbers of set. So very fascinating and very beautiful aesthetic appearance of the set. So that it has the customer has the attracting features, and they can visit the place, commercial place again and again. Now this is a sanitizer. You know that at the time of COVID, this was very important. Now if I say about the pharma products, you can say that different same technology is there, but their designs are different. Similarly with this textile and jewelry industries, although we have the different designs of the jewelry, and all these are applicable for the design registration. Textile, we have the different fabrics of the textile, and it is also can be protected for the surface pattern of the textile and jewelry. Both these you can see that it will be protected under the surface pattern. Now the consumer products, these are the different consumer products. On the basis of shape and configuration, you can protect the design registration. Again, this is on the basis of safe configuration and surface pattern, it can be protected. These are the certain designs of the toy, school bus. You can say that different cartoon characters that are very famous among the kids, and you can make any design of the biscuit till this is instrument, any stationery, and it can be applicable for the design registration. So now this is the traffic light signal which has been invented in 1923, and again the main point is that it saves millions and millions of life daily. So you can imagine the utility of this invention. So the main purpose of IPR is again for the welfare of the human civilization. Now this is the small businesses. You can go on the basis of the design registration, and you can also contribute for as a startup. So these are the registered design on the basis of the set. You can see that this is the clothing set, and the purpose is again the same pattern is there, same design has to be followed, so that they can be qualified as a filing your article for the as a set. Now this is the design made by the NID Ahmedabad for lifting the heavy loads, and so that their neurological system can be protected due to the repeated lifting the heavy loads. Now this is the semiconductor devices which has been protected for 10 years, and registration is valid for the 10 years. You have seen that semiconductor devices and so many devices are there for which it is very important. And what is the process? So you have to apply through the LD1 form, layout design 1 form, in which the fees of filing is 5,000 rupees, and in which there is input output PADS system, register, transistor diode via metal track, ground via metal track. All these things you have to apply through this. Okay. So, and when you will apply, so after it will be go for the examination, and after the examination, if any requirement will be there, office will registrar will ask from you, and you have to submit it, and after acceptance it will go for the publication, and publication means we will wait for opposition, and if no opposition will come up to 3 months, it will go for the registration for the issuance of the certificate. So the point is that in the patent we publish just after your filing, but in the design, SICLD, trademark, copyright, we publish after the examination. Okay, so this is the basic difference in patent publication done at the earlier stage. Now, if you say about a trademark or brand name, so you know that a word, name, symbol, brand, numerical or combination of colors. Through this, you can protect your branding or brand name. You have seen the Tata, Bata, Airtel, Coca-Cola, Maja, Pepsi. All these are various popular brand names. Now you have also seen the musical system. IPL match, they have a special type of tune. Kaun Banega Crorepati, they have a special type of tune. Even in the Netflix, Amazon Prime. So when you listen that sound, even within a fraction of second, you understand that they are indicating any any services, which type of services, so that you get easily fascinating about that. So now it distinguishes from the goods of the others. Now, you know that the purpose of this trademark to the advertise your goods and services as well. And now the second point is that you have to protect the innocent people from buying bad quality of second rate quality of the goods. That is the again main purpose of is here. And if it is written R with a circle, it means trademark has been registered, and TM means trademark has been applied, but registration is still pending, and duration of registration is 10 years, and it can be renewed every 10 years subject to the uses. Okay, now what are the subject matter? You can apply for the trademark. It may be a trademark, trade names, collective marks, certification marks, taglines, slogans. You can say that this is a word Google, website name naukri.com, ye dil mange more, this is logo, picture, design, letter, anything can be used as a subject matter of trademark. So you know that the Maggie, how so through this trade marketing, it captured the complete market. It initially came with the 2 minute में तैयार हो जाएगी, and it is a solution for your appetite. वो इस through this method it came into the market, and after that the Maggie market again came down, and it again came with the new slogan, आपके किचन की जान वापस आ गई. So it again connected with the kitchen. So you have also seen the big basket. Although you are feeling good or not, that is your personal opinion, but big basket will realize you that you are getting better when you deliver your item within 5 or 10 minutes, you get delighted. So they are making you in that manner. So that is the advertising or branding of any goods or services, so through which you can also take the help of this trademarks symbol, and you can file in our office so that it can be protected to protect your business. So now geographical indication is there. It is provided on the place name. Since it is a public property, so it is provided not to the individual. It's provided to any society or the community or the group of the people. It must use to identify the source of the original quality or reputation, and it must have the distinguished features and characteristics feature from the previous existing. And so now let us see the certain examples of the geographical indication. So first word indicate the geographical region, and second word indicates the product name, Darjeeling tea. And you know that Darjeeling tea is the first product for which we got the geographical indications. Makrana is the place name, and marble is the product name. Ratlami save, you can say that the save can be manufactured at any place, but the taste of river water, that makes the unique taste, and it can be manufactured at that place. The river water which flows into the Madhya Pradesh, so it cannot be manufactured at any other place. This is the Kanchipuram silk. कठपुतली जब राजस्थान, बाग प्रिंटिंग of मध्य प्रदेश, बंगाल पदचित्रा, वर्ली पेंटिंग, बर्डी वेयर, चरियार पेंटिंग, कुर्ग ऑरेंज, शाही लीची of Bihar, एप्लेट मैंगो, मगही पान, कश्मीर saffron. So you can see that these are the different varieties of the product, which has the special feature from related with that geographical area. Now come to the copyright. Copyright provides you an automatic right. Suppose that you have written any poem and you want that and just you have completed writing the poem, so from that time only you have the complete right on it. You need not go to the copyright office for getting it to be registered. So in that manner it's a automatic right. and from the starting of its generation. And it also provides the bundle of right. So these are the certain bundles of right: literary work, artistic work, dramatic work, musical work, sound recording work, and cinematographic film. So you can also this section associated with it. Now the point is that although it's a not a compulsory right that you have to take in, you have to take this, but the point is that if I say about the infringement purpose, and if you feel that if there might be certain public can use your misuse it and go for the commercial exploitation, in that case you can go for the copyright protection as well. And who are the authors? Authors means creators. Suppose that I am delivering this lecture and somebody takes my picture, so I am not the author. Author is the person who has been created it. So similarly for the music composer is the producer, the cinematographic film, so author who has written the book. Similarly you can imagine who can be the author of the work. And terms of protection is life of author plus 60 years. Suppose that you are a very good in have a certain understanding of any subject, so you can write a book and you will get the royalty up to your life, and after your life your next generation up to 60 years they will also get the royalty for that. So that is the main fascinating feature of this time. Term of protection is very huge in the field of the copyright protection, and for the cinematographic film it is again 60 years from the date of publication. And the prescribed fee, if we say that it's 500 rupees and 2000 for the artistic work, sound recording it is 2000, for the cinematographic film it is 5000 rupees. So fees varies from 500 to 50,000 rupees. So it depending on it is being filed by an individual or any society. So now come to the trade secret. To trade secret, suppose that you have made any herbal drink and you want that the chemical formula, client database, financial strategy, experimental result, recipe, you should not share with anybody. So under trade secret, you have the complete freedom that you should not share all these things with anybody. So why, when it is preferable, you know that patent is being provided you for the 20 years, but any technology, if you want to keep your protected, so you should not file the patent filed up for the patent, because for beyond 20 years it can be protected under trade secret only. So what is the difference between trade secret and copyright? If I say that, so when it is when any process, any technology is within you, so it is trade secret. And when you publish it and when you publicize it, it becomes the copyright. So that is the difference between trade secret and copyright. Okay. And now how to safeguard it? So by signing the confidential agreement, and in that agreement also you should not mention any trade secret matter. Only you have to mention your business partner, your employee's name. So that if in the case of any conflict in the agreement, you can go to the national legislations and you can claim for all types of damages and injunctions. Now the today's scenario is that you have to protect your product in every manner, in every scene. Why? Suppose that any technology is there which has the LED display, and for LED display you have the technology. Now for the technology you will get the patent. It might be possible that some other company, they have the same, they will also get the same technology, but their method should be different. So that technology can also be incur with them. Now the second part is that how your technology look likes. So that's why you have to put the design. So body of the laptop is there so that it can be protected under design. Now you have protected it, made it. Now what is the purpose? You have to commercialize this. So for commercializing, you have to put a certain trademark. Suppose that it's Apple, it's the Apple sign. You are very familiar with this. So with trademark, it becomes more and more popular. And again, if the thing of the copyright, user manual, whatever the written text or documents, and if there is any public performance or there any advertisement, for that also you can go for the copyright. So single product can be protected under multiple intellectual property right. And similarly with the SICL DL, SICL design is also there. For that you can also go for the copyright protection. Circuit design, you can also take the protection for that. Now this is Coca-Cola bottle. So For the technology, for this capping or this bottle, you can get the patent. For the liquid, trade secret is there. Coca-Cola is written in terms of the trademark. And for the design, you can go for the design registration. And copyright in text of the copyright in the text database or any artistic work. Advertisement is also there on the website, on the television. So all these are the copyright work. Now the relation between IPR, again for the similarly with this mobile, you can go for the different IPR protection. So now you can a simple approach, you can also become a scientist. So identify some problem and solve that problem, and you can apply for the patent. Now the point comes here. So how to identify the problem? So you have to invite your common people or the representative of the common people at your institute to share their problem with them. And if you can able to solve the problem for that, so so there might be chances of the commercialization, because if you will solve the problem, they might interested in your solution, so they can go for the commercialization also. And in same manner, you can also get the commercialization, and you can document it, and you can apply for the patent. Now, what can be patented to any process or product which have the new novelty, inventive step, and capable of industrial applicability, and it should not abide by the section 3. Section 3 says that if anything is against the public order or sentiment, against the nature, anything is discovery, mere arrangement or rearrangement, or again the process method of treatment, plant or animal species, all these things are not patentable. Okay. And the product includes apparatus, devices, machines, chemical products, etc. And inventions have the novelty. Novelty means it must be new. It means it has not been published in India or elsewhere, and it is not in the prior public knowledge, and nobody has claimed before you're claiming. That is the main purpose of this novelty. And it must have also the inventive step. Suppose that Thomas Alva Edison has invented the bulb, and there are so many modifications of that. Mouse is there, computer is there, monitor, printer is there. Everybody has, we had so many modifications, and all these modifications are welcome as the under the inventive step for the patenting. So, and economical significance, suppose that any glass is there, which is available at 10 rupees. Now you are manufacturing and you are selling into the 2 rupees. So since you have reduced the cost somehow, so you can also file on the basis of economical significance also. And now some indications of the non-obviousness are, suppose that you know that dengue, malaria, Haiza, chikungunya, there are so many diseases. We don't have any early diagnosis kit or early diagnosis parameter. So if somebody can come with that, it may be a solution for the long-standing problem. And it has to be used in the industry, and it has to be capable of being made in the industry. Suppose that water is there, so you know that turbine bijli is produced through that water. So water has the industrial applicability. When it becomes heated or superheated condition, again it is being applicable for the industrial applicability. So you are using any product or process. So thing is that how it can be used in industry, it has to be applied. Now, if you say about the in essential ingredients of the complete specification, so it is also the form 2. When you have to file the patent, you have to provide the title and preamble, field of the invention, object of the invention, prior art, effort, summary, statement, detailed description with reference to drawing, examples, and lastly claims. Since claims decide the scope of your invention, boundary of your invention. Suppose that you file your invention for the patenting, and in that patenting, when you will get the patent, what you get in the patent, since it is in the documentation form. So in that documentation, you will get the protection for your claims. What are your claims? Since you are going to commercialize, so you have to license your claims, that these are my 10 claims and I have to commercialize this. So that is the main purpose of this claim, and it has to be written in a very careful manner. Okay. So now this is the drawing you have to provide so that your claims and other descriptions should be supported. So sketch drawing is important, and this is reference numeral. It has to be also provided here. And now this is the way you can write your claim. So claim start with either I claim or we claim. It means in the complete world, only you are claiming, nobody else is claiming it. And the claim number 1 will be the independent claim and rest of the claim will be the dependent claim. So the point is there, in the independent claim you have to put all your constructional and technical features, but in the dependent claim you have to put show the dependency from the independent claim. You cannot put any new feature in the dependent claim. If I say about the patent filing process, any individual, legal entity, small entity, startup, or can jointly file with the above, and it can be filed at the offline and online both forms. Online it can be filed at the office 24/7. Online, offline you can file at the official time only. And if I say about the jurisdiction, so for the New Delhi, state of Haryana, Himachal Pradesh, Jammu Kashmir, Punjab, Rajasthan, so they can file their application at the New Delhi, National Capital of Territory of Delhi, Union Territory of Chandigarh, Delhi. They can file here. So the point is that we will also share you the feedback form. In that feedback form, this is whatever we are discussing, it is also attached in that sheet, a PDF. It is all available in Hindi or English. You can download it, and for the jurisdiction purpose you can see in further where your location resides. And for the design filing, it's a jurisdiction free. You can file your application at any place, New Delhi, Mumbai and Chennai. So these are the minimum documents. So in form 1, we have to apply form 1. In form 1, you have to provide your name of the applicant, nature of the applicant, whether you are a startup, institute, industrial, or ordinary application. And again, you have to apply for the um, and title of the invention, and who are the inventor. If inventor and applicant are different, you have to provide the signature. So all these things you have to provide in the form 1. And form 2 we have already discussed. In the complete specification, either it is complete or provisional. If you have filed provisional specification, within 12 months of the time you can file your complete specification. And if it is not possible to file, you want 6 months extra time, so you can also take the 6 month extra time for filing the complete specification. Incomplete specification claims are mandatory. You have to provide the claims. OK, and in form 3, you have to provide the statement of the foreign filing. So if you have filed outside India, and form 5 is for the declaration as to inventorship. And form 18 is important for request for examination. Without form 18, we are not going to examine your application. So these are the basic online filing fees: 1,600 for the natural person and 8,000 for the company. And for the form 2, there is no fees up to 30 page, and beyond 30 page, for each page you have to provide 160 rupees. And up to 10 claims there is no fees, and beyond 10 claims, for each claim you have to provide 320 rupees. And hard copy filing you have to provide additional 10% extra. And form 18 online filing fees is you have to provide 4,000 for the natural person and 20,000 for other than natural person. So with 4,000 plus 1,600, so 5,600, with minimum this amount you can file your application. And if you want early publication, so through form 9, you can also provide the early, you take the benefit of the early publication within 1 month of the time, and fees is 2,500 rupees. If you will not file the form 9, it will be published after the 18 months of the time. And expedite examination provision is also there. For 18A, you have while filing PCT, if you have chosen India as a ISA, or if there is any female applicant, on the basis of that, you can also go for the expedite examination. Or is there any startup, it is also applicable for the expedited examination. So this is the timeline I will discuss in the flow chart. This is our official website: patent, design, trademark, geographical indication, RG and IPM. And through this, it is complete. You can file your through comprehensive e-filing here. So for the filing patent, design, trademark, you can use this link for filing. And you can also conduct the public search, so that you can get the latest update also, or any information from here also. See, here it is copyright filing column is there, SICLDR, some circuit design filing is there. And for any manual or guideline, you can see see here. To in a single platform, you get a multiple of information on our official website. This is our official website also. You can also go through our website through this platform. Now, this is the flowchart. When you file your application, it will go for the digitization, and after that, screening and classification is done. And after classification, if it is has been filed with through Form 9, it will go for the early publication, and without Form 9, it will be published after 18 months of the time. Request for examination, it has to be provided within 31 months of the time, and it will be allotted to the examination group, and it will be within 6 months of the time. You have to provide the reply, and after getting the reply, if it is satisfactorily, it will be going to the grant. If there will be certain issue, you will offer an hearing, and after publication and before grant, anybody can file the pre-grant opposition, and after grant also anybody can file the post-grant opposition also. Since in the patent publication is done early, so there is both provision for the pre-grant and post-grant opposition. But for the design, trademark, copyright, you have the only provision for the opposition after the granting by our office. So for the design filing, the fees is 1000 rupees, and for the company it is 4000 rupees. And through this, applicant full name is there in the form 1, nationality, legal status, everything you have to provide here. And you have to provide the class number and name of article in the design. Okay, this is very important. What is the class number? Since in the patent, class number is being provided by our office, but for the design, class number is being provided for your side. So it is decided by the Locarno classification. There are 32 classes and 237 subclasses. So you have to decide for which class you are going to file for your design registration. So suppose that you have made any clocks and watches, new design, so you can apply under the class number 10. Any photographic or cinematographic and optical instrument, so you can file under the class number 15. Any printing and official machinery or any musical instrument, so you have to select the class, because we will search for that class only, that instrument is available in that class or not. So this is the details of the representation sheet. We directly go to the representation sheet. So this is on the top on the top left, name is there, top right, total seat and seat number, bottom left, date and signature of the applicant is there. It is the representation sheet. You can see it should be colorful and no number reference numeral is being made, and you have to put only the novelty what for which you are going for the design registration. So here it is written, novelty is being decided in the shape and configuration of the teapot. So this is the shape and configuration for which you are going for the novelty, and there is no disclaimer. You have to provide that disclaimer also, that you are not going to put any technical feature or any words, letter, number. You are also not going to claim that. So in this will make your representation sheet complete. And we also require 360-degree view of your design. So bad quality pictures are not applicable. Our office has also started the SIPP scheme. Through this scheme, the fees of the agent will be filed by our office. Okay, so only the government fees 1600 plus 2500 will be paid by yourself. So in our official website, you can go through the SIPP scheme and you can see all the benefits here. And you have to take the help of the TISC Center, Technology and Innovation Support Center, and through that center you can contact them and they will contact you for the impanel facilitator. And mandatory condition that all must be Indian, and you have to take the help of the panel facilitator. And for the startup, this is in panel TISC center is not applicable. You can directly go to the panel facilitator. Self declaration is required that you are not availing funds from any other government scheme. So if we say about for the Kapila scheme, it is launched by the Ministry of Education. Target is for the academic institution and research. Objective is to promote patent filing in academia. That is the main purpose. Okay. So now you can through Kapila IPR cell provide the funds indirectly from ministry. You will not get the fund directly, and for the incentives for the faculty and researchers. So all this is from my side. Thank you very much for patiently listening me. And now, if you have any question, you may ask to me. And please fill the feedback form. Within 15 days of the time, we will provide you the certificate, and all the details have to be provided correctly there.
Well, thank you very much, sir, for this insightful presentation. Now I request all the participants. Yes, Mansi, you have a question. You have raised your hand. Mansi, I will unmute your mic. You can ask your question. Yes, Mansi, now you can switch on your mic and ask the question. Mansi, you there? Sachin Kumar, now if you have any query, you can switch on your mic and can ask your question. You are also on mute. Neha Yadav, you have raised your hand. You can also switch on your mic if you are having any query. You can also put your query in chat box or Q&A. Sir, we have one query from Dr. Ruben Shah. He have a query that I have a question related to this, that I have seen Redmi and Xiaomi mobiles use the design of Apple iPhone. How are they able to do this?
So they are not able to do that because if they are able to do that, then they can infringe, put the case against the infringement, that and they have to show the design. What is the difference between design of the Apple and iPhone? Sometimes it's assume resemblance. So. Uh, but there is a slight difference in the novelty because the definition is important for that. So because novelty is if the slight difference is also there, na, so it goes for the novelty. So it's not 100% copycat. So there might be certain difference, and that is applicable for the design.
Well, few other participants raised their hands for Q&A. They have been given access to switch on their mics. If they have questions or any queries regarding the session, they can ask right now, or they can also, yes, Mansi, you can switch on your mic, or they can also put their questions in chat box on Q&A. The link for feedback has been shared in the meeting chat. They can click that form and fill up the feedback. PPTs will be shared accordingly on your emails. Sachin Kumar, you have been given access to switch on your mic. You can switch on your mic and ask the question. Or if you are not able to, you can put your question in chat box or Q&A section. Any other participants having any query? I think no one is having any further queries. Yes, we have one query from this. Kundan is having one query. What is the current applicability of Section 3D of Patent Act? Is there a need to reform IPR laws to accommodate growing needs of the industry?
So it is always for the growing needs of the industries also. Mere arrangement and rearrangement is not patentable, and you have to show the synergistic effect or the applicability. What are the technical advancement? So that is important. So on which basis you are saying it is again, suppose that pencil and eraser is there, you are just connecting it and saying that I need the patent for that. So it has to show, you have to show the efficacy of your product, that what is the more efficient you are using it. So that is important. So it is for the industrial purpose also. So they have to put some extra effort.
Well, sir, we have another query from Mr. Rajesh.
Yes,
In
yes.
Harpic versus Godrej Aspix, Racket Bannister holds active trademark registration for the bottle shape. the original design registration for the bottle has expired. Can it valid or protected under this IPR? Please provide your
No, nothing. See, TM for the trademark, the first point is
trade.
that it should not be in the public use. So even if suppose that McDonald logo is there or any bottle design you are saying, so they have not filed the trademark. Even you go to the court that I have the protection for this design under the trademark and this person is not. So court will give the preference to the person you are using earlier. It is on the basis of early use. Okay, so as trademark and copyright is not a compulsory right that you have to take it. So it is always benefited to the first user or the early user. Okay, so you will not, it can be not be protected under the TM.
What's a Kundan has given
Again, the
there
same thing.
are
You just check now current applicability. Just a theoretical question. You can see it. Again, I have said what I will say again. What is the current
okay, so
applicability of
yes, sir.
section 3D is not patentable. I am saying this thing.
Okay, sir.
So what is
Sir,
your,
now
please be specific so that it can be SIPP scheme, the procedure for registration. So procedure is simple. You have to only put in the form 1 that you are filing under the SIPP scheme, and patent facilitator you have to, they will file on your behalf. You don't have to file. They will file on your behalf. Patent facilitator, you can scroll on your our website SIPP scheme, and you can check the list of the panel facilitator, and you can contact to them and they will file on their behalf, on your behalf.
so this
So
is another.
again the same concept is territorial in nature. Patent law is territorial in nature. You know that software is not patentable in our India, but is patentable in US and European Union. So it's a, you have to follow the section 3 of our Indian Patent Act. We are not here discussing to what is law allowed in US or EU. So you can file your application in that country. So it might be possible.
So now we have another query from Ria Patel. Many products with low quality on Meesho and many other websites. The product looks like the same branded product, but they are not same in quality. However, this is
So
valid to
how
sell.
whether how we are patenting anything, we are quality doesn't matter for us. Quality is for the end user. How you can define the quality depends on you. So we have to check for the novelty or inventive step, and it is trade marketed or not. This is not, there are other separate department in the office. We on the government we check for the quality. So this is FSSI is there. So many other departments are. We are not have the same purpose for that. What is the advantage of patent? So you can understand that there is nothing decided. If there will be any advantage, then why should be here? Even if you will ask the advantage, I will say that because you buy the gold. Now you are buying the paper gold. So you are selling the technology. Now you will sell the paper technology. You can raise your share market. You can collect the crowdfunding. So if you have any disadvantage, you can disclose. I don't think that there is any disadvantage of the patent. So you are so NBA, it will take too much of the time. It's not simple that NBA is biodiversity. You have to file an application with the different institute, and you will get the permission under NBA. After that, you can file your application in our country. So granting, so it is not getting commercialized. So this is not our duty. Your product is not useful for the person. So how anybody can interested in your product or process? So there are so many products. Are you able to buy each and every product in the shop? What is your utility? You will buy that. So you have to make your invention or your patent just like that. It has the commercial value, and everybody should get attracted for it. So that is the main purpose. So in that manner, commercialization is not just a you can say that it can be done in like manner. So I don't think, sir, please stop. So many questions, sir. There is just irrelevant. I am not feeling that they are just for just writing anything. So that is sufficient.
Sir, you're on mute, Ahmed sir.
Now we'll proceed further.
Sir,
Now
I
I
have
would like,
another session at 12, so please close the session.
sir, just 5 minutes. Now
They are calling me again and again.
now I request Dr. Silky Gaur, Area Chair Marketing at NIT Business School, to please give the concluding remarks. Ma'am, please. Ma'am, you are on mute.
Sir, on behalf of NIT Business School, I express my gratitude to you for sparing your valuable time with us. If you could please accept a virtual token of appreciation from us, that would be great, sir. Hoping to welcome you in person at NIT Business School in future, sir. And I'm sure that today's session would have benefited our participants from industry, academia, and even our students who will be future managers, entrepreneurs, and they will be dealing with all creating new products, launching startups, developing technologies. And I urge everybody to not just innovate, but to respect, protect, and promote intellectual property rights, as Sir mentioned today. Over to you, sir.
Thank you,
Uh,
ma'am.
Thank you very much, Dr. Gaur. Now I request Dr. Pooja Kapoor to kindly present the vote of thanks. Ma'am, please.
Yeah, thank you, sir. On behalf of NIT Business School, Greater Noida, I would like to express my sincere gratitude to our esteemed speaker, engineer Kumar Raju, for delivering such an insightful session on intellectual property rights, patent and design filing. Sir, your guidance and practical insights were extremely valuable and help all participants gain a better understanding of this important subject. I would like to extend my heartfelt thanks to Dr. Arun Kumar Singh, Director NIT Business School, for his constant support, encouragement, and vision in making this workshop possible. Of course, I also sincerely thank the head KGP NIT Business School for the guidance and support provided in successfully organizing this program. My gratitude also goes to the management of NIT Business School for always encouraging, such academic and professional initiative. I would also like to thank the Rajiv Gandhi National Institute of Intellectual Property Management and the National Intellectual Property Awareness Mission, Government of India, for their collaboration and for taking such an important, initiative to spread awareness about intellectual property rights. A special thanks to the IT team and the IPR team, especially Dr. Ahmed, Dr. Silky Gaur, and Mr. Sarvesh for their valuable support and effort in making this workshop run smoothly. Finally, I would like to thank all the participants for their active participation and, which made this workshop a great success. Thank you, everyone, for your presence and support. Thank you.
Thank you very much, Dr. Pooja. Thank you very much, our team resource person, Shri Kumar Raju. Sir, as we know that you have some other engagements. Thank you very much for tuning in. It has been a great success for us, an insightful session for us. So you may leave the meeting. Well, there is one announcement to all the participants. The feedback link have been shared in the chat box. It will also be shared to each and every participants via email. So you have to fill up the feedback and other compliance, which will be communicated through email. So thank you all the participants for tuning in. You may leave the meeting. Thank you. Thank you very much.
Thank you, sir.